discourse, maybe in the form of the kinds of publications we've seen, like Shamila Bush's recent book, for example, or indeed this morning, and I don't want to be discourteous to one of those who have supported this conference, but I was struck, and I have to say, somewhat distressed by the comments made by our opening speaker, the ambassador, who spoke about his discussion with Bangladesh's Prime Minister and referred to her oblique they, Bangladesh, as being, quote, worked up about things. I think he's right, we are worked up about things, and probably we're worked up about things for very good cause, precisely because of these elisions and ellipses in the discussions at a global level, and the inability, it seems, to confront the past and how that contours the present. So what I want to try and do is talk through three issues, and if you like, three different kinds of encounters with processes or structures for seeking justice. I'll start, I guess, given that we have talked about 71, with the issue of facing and naming the past, and with the efforts to end impunity and seek justice for war crimes and crimes against humanity. After that, I want to talk about something drier, and I hope you won't fall asleep, but I want to talk about what actually is for me the most important issue, and perhaps for Azazasam also the issue of independence of the judiciary, and about the institutional process that we have for trying to deliver and effect justice. And thirdly, I want to talk particularly about the pressures which the judiciary has faced, and the subordination the judiciary has itself embraced rather too heartily, I would say. And thirdly, I want to talk about the role of, that is involved in terms of reducing democratic space. And then thirdly, I want to talk about how people's organizations and citizens groups have worked to fight and maneuver for some kind of representation of their own interests within the narrow spaces that are available to us within the process of justice. So to begin at the beginning with the issue of 1971, with the unresolved question of crimes against humanity. The problem of impunity, which of course marks 71 as well, is deeply embedded in Bangladesh's justice system. In the darkest times, it was grafted onto the constitution by military rulers through indemnity laws, and it continues still to permeate and obstruct efforts at seeking accountability. The horrors of massacres, political killings, and violent conflicts have smeared our landscape over 40 years. Many of these are known to you. Of course, the assassination of our first president, Sheikh Mujibur Rahman, and most of his family, subsequent killings of our prime minister and other leading politicians in jails, the secret trial and hanging of Colonel Tahir under General Zia's regime, killings within the military throughout the 70s, and of course, massive brutal killings of civilians throughout the entire period, which are not so much recorded in the grand political histories. All of those, as I said, the blood of all those people has smeared our landscape for 40 years. But I won't talk about all this here. I'll try and focus on the issue of war crimes and the effort that is now being made, finally, with the establishment of the International Crimes Tribunal, based upon a statute which was first enacted in 1973 in the immediate aftermath of the War of Independence. It was a statute which was then developed on the basis of input from international lawyers, and based, if you remember, in 1973, very much on the notions and understanding of international criminal law at the time, based really on an understanding of justice for war crimes premised upon the Nuremberg tribunals and those principles. This was long before the Hague tribunals, long before Bosnia, long before Cambodia. No notion of those kinds of principles that had been developed there were available to us. The purpose, so we have this slight anomaly in that we have a piece of legislation from 1973 being revived in 2010 and created, and enabling the creation of a tribunal to try crimes of 40 years ago. The purpose of this tribunal is limited. It's to try those Bangladeshis who were involved in committing international crimes, including crimes against humanity and genocide. Currently 7 men, all of them who are being leaders of opposition parties, 2 from the main opposition party, the Bangladesh Nationalist Party, 5 from the Jamaat-e-Islami, are in detention. And one of them was last week indicted on 20 counts involving crimes against humanity and genocide. And sometimes it seems that it's unknown to recent international observers of this Bangladeshi trial process that the development of the establishment of the court has come in response not simply to a flick of a wand by a government which is hell-bent on destroying its opposition. I won't say that they don't have that as a motivation, I'll come back to that, but it hasn't come only because of that, and it couldn't have come only because of that. This development has come in response to decades of unrelenting struggle and demands from civil society, including freedom fighters, survivors groups, and rights organizations. And it also came in the wake of an election in which the pledge to hold such a trial appears to have contributed significantly to its outcomes, and particularly in terms of the influence it appears to have played on young people as a factor for bringing into power the current ruling coalition.